evening. The 2014 Village of Sister Bay Board Review is hereby called to order at 5:05 p.m. Present are
Pat Duffy.
John Clove.
Scott Baker.
Donna.
Christy Solly.
Dave Leon,
Randy Nesbitt.
Donna Scattergood.
Nora Zacek.
Pam Hampshire.
Troy Zacharias, Assessor.
this board review has been called to order. Notice has been publicly posted as required by law. The assessor will now sign the assessment roll and the clerk will witness his signature.
And you can have.
If you have any noisemakers, would you please silence them or put them on vibrate? This board review being in session will now proceed to hear objections.
Okay, the first one is West Capitol. That's the government lot, or parcel number 1810007312822A, and it's on Little Sister Road. Attorney Potter and Martha Huber-Pelrine, would you please raise your hands? Mr. Zacharias, do you solemnly swear in the matter now in hearing to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
I do.
Okay, so would you like to start?
Yes, thank you. On behalf of the objector, West Capitol, I would like to start first by pointing out to everyone on the board, there is a typo on the objection sheet that I wanted to point out. I think it's probably fairly obvious for some of you. Under number 5, undeveloped classification number of acres, 16.86 at, and it says 20,894. That number should actually read 208,944. There's a decimal missing. It says dollar sign acre at 50% of market value of 176,140. That one again is also missing a decimal. Should have been 1,761,397. Probably could have gathered that by reading the addendum, but I want to make sure that it's clear for everyone before we get moving. Okay, I would like to start with Martha Luber-Pelrine. Could you please state your name?
My name is Martha Luber-Pelrine.
And are you here today as an agent for West Capitol Incorporated?
Yes, I am. I'm representing my father.
And your father
It was
is?
Fred Luber.
And is West Capitol Incorporated the owner of the parcel that's bounded by Little Sister Road and Pebble Beach Road?
Yes.
And that's the parcel number that was read by the clerk just a moment ago?
Yeah, I hope so.
Can you tell me, do you know that West Capitol, whether or not it's owned this property since 1971?
Yes, they have.
So about 43 years or so.
Yes.
And during that 43-year period, has West Capitol developed this property in any way?
No, it has not changed at all, except there's a few less pebbles on the beach.
So West Capitol has taken no opportunity to develop that land, to harvest the timber, to do anything with that property.
We've done nothing with it.
So as of January 1st of this year, were there any dwellings on the property?
No,
Any residences of any sort?
no,
Are any goods manufactured or fabricated on that property?
no,
Are any goods sold on that property?
no,
Has that property been used for buying and selling of any type of good?
no.
at any time during the past 5 years has West Capital leased that parcel or any part of that parcel to a tenant?
No,
Has it received any rents for use of that property?
no,
Has it leased to any person or sold any mineral rights?
no,
Has it received any royalties for any reason from that property?
no, I wish.
And has it leased the property for any type of farming or agricultural use?
No,
Has it leased or sold any timber rights?
no,
Has it received any sort of income as a result of harvesting timber?
no,
During the last 5 years, has West Capital realized any type of income or financial benefit as a result of owning this property?
no,
So there is absolutely no benefit financially to West Capital to owning this property.
no. It's actually a huge responsibility picking up the garbage from the people that use the beach without our permission.
Does West Capital have any intention of using this property?
No, not at this point. I mean, we don't really have a plan for the future.
So does West Capital have any intent to buy or sell goods off of this property?
No,
Is there any intent to harvest any timber?
no,
To extract any minerals?
no,
To use this property for any type of commercial purpose?
no. That would be not beneficial to our other adjoining property, the Little Sister Resort and Fred and Fuzzy's.
So the adjoining parcels are owned by West Capital or a different
So
organization?
it's owned by my parents, Fred and Ann Luber, and Greg and Sue Sunsberg, in a 60-40 arrangement.
And so why do you say that it would be detrimental?
Well, I mean, obviously Pebble Beach could be a prime spot to, sell that someone build a resort or whatever, but that's sort of like competing with what we already have there. And it would lower the value and the scenic beauty of Little Sister Resort and Fred and Fuzzy's.
So there's absolutely no intent for West Capital to do anything with a commercial purpose for this property?
No,
Any intent to use it for residential purposes?
no,
Does West Capital have any intent to rezone the property to obtain an unconditional use permit to allow residential use?
no,
And are all of these statements true as of January 1st of this year?
yeah, they're true as of however long ago, 45 years or whatever.
Is there any way that you would characterize this property as being productive?
No,
And did you feel that way on January 1st?
yes.
What is it exactly that West Capital is going to use this property for?
Well, that's a really good question. I think it was bought originally, I was a child, with the intent of protecting the bay and keeping it beautiful bay that it is. And back then, the tax bill wasn't so big and the land didn't cost as much as it does now, and things have changed. And honestly, when it comes down to my generation, there's 7 of us involved, all spread around the country, and we all have very diverse opinions, and I'm not sure how that's going to work. And we approached the Nature Conservancy, we approached the Stark County Land Trust, and both of them said no, for different reasons. But
So currently, West Capital is really using this property as preservation.
yeah, yeah.
In preparing the property assessment, were you contacted by the assessor to ask what West Capital intends to do with the property?
No, I mean, I'm the only one that lives here year-round, and I don't think we've ever been aware of when the assessor's been there.
All right, I have nothing else for Ms. Luber Alvin.
Mr. Zacharias?
Troy Zacharias, I just have a few questions. Now, is it Mrs. Luber? Or,
You can call me Martha.
I understand it's just a wooded piece of property with shore frontage. It's 16.86 acres. I guess one of my questions is, it is zoned commercial. At some point, one of the owners had changed it to a commercial zoning, and I guess, well, I'm looking to find out why they had changed it at some point.
I can't answer that. There's never, I mean, before it was West Capitol, it was Joe Downey and Fred Lieber, my father and his business partner, who really are West Capitol too. And there's never been any intent to develop it. You know, and that goes back to, I think it was originally purchased in 1967, before West Capitol was around.
Okay, because that was, I guess, one of my questions, because it is zoned B1 or, you know, I think that's general business.
Yeah, I mean, my dad will be 89 this summer. If he wanted to develop it, it would have happened long
Sure.
before this. You know, and I mean, we've had that question too with the recent transaction with St. Martin's Island and the Nature Conservancy. And I mean, my dad is a World War II vet who was a build and develop kind of guy. But his actions speak a lot louder than his words. I mean, St. Martin's, he was like, oh, we'll develop and whatever, and that's recently been turned over to the Nature Conservancy. And he wants to keep our bay the way it is. I mean, we're lucky enough to do that.
And I guess you had said the Land Trust or Nature Conservancy wasn't interested in the property. Is there a reason why it wasn't?
The Nature Conservancy does everything based on biodiversity. And Pebble Beach property is basically, it's beautiful pebbles and a beautiful beach, but it's cedar trees and garlic mustard otherwise. It's not biodiverse. And the Land Trust, they don't do shorefront, and they don't want to deal with the policing problem that is down there. I mean, you guys all know what Pebble Beach is like. You know, it's in the 100 places to visit in Door County before you die book, or whatever that thing is called. I mean, it's a huge issue. And it falls on my shoulders because I'm the only one that lives here year-round.
And I guess my next question, you may not be able to answer, but I mean, if, you know, West Capitol wants to preserve it long-term, that's great, I guess, but at some point, why didn't they look at doing like managed forest or
we
something
did
in
look
that
at that at
neighborhood?
one point.
Just let me finish the
Oh,
question.
okay.
You know, it was just, basically, that was the end of the question. It's just, why didn't they look at doing managed forest? Because you could have did that for a 25 or 50 year. Previously, when they had purchased, I think there was forest crop law and a few other type of woodland type programs.
We had a forester for St. Martin's that came down and looked at it, and told us it had to be 17 acres. Was one of the reasons. And the other reason is you have to allow public access all the time. And it's sort of happening anyway.
Well,
You
no,
know.
just clarity, I do have some property in managed forest law, and there is two types of programs. One is 25, one is 50 years, one is open, and one is closed. So and I've owned, I've almost 25 years already that I've had it in managed forest. So you could limit trespassing as you do today. And it is a minimum of 10 acres into the managed forest. So I'm not sure.
Well,
I'm
this was
just.
like 10 years ago, 12 years, I don't know, something like that. And
But you may have gotten some misinformation from whoever, because the managed forest, like I said, I've had it since 1987, 1988. I've had land in managed forest, and I'm enclosed, and, you know, it's a 25-year program, and I've got to re-up it. And I do not, you know, I paid a little bit extra due to the fact that I don't allow trespassing on it. I want to control that, so.
well, maybe we need to look around.
That may be an option, because right now I think it's about $8, $9, $10 in lieu of tax per acre. So you'd be looking at a fairly minimal tax bill. You know, the only thing is over time, and I maybe going a little farther out of the way, but over time you would have to log or thin it a little bit based on the plan that would be set up by the owners and the forester. So I guess that's all the questions I would have for Martha at this point.
Want to proceed with,
I have nothing further for Martha. I would turn over to Mr. Zacharias.
Nothing further from the objector?
Nothing further.
Okay. Very well. I hope I made it.
You can share. We can share.
Sure.
Got enough for you?
Yep, I do.
Thank you.
Just one procedure item before we move forward is that, just to clarify, the value of the claimed of the property, is the value that you're asserting 1,700,000 and, 761,397 as you corrected the objection form on the front?
That is correct.
Okay, very well, thank you.
Okay, my name is Troy Zacharias. I'm with Action Appraisers and Consultants. I'm the village assessor. What I've got is I've got a packet that I handed out. It is numbered, I think 1, 2, 3 through 4. There is some underlying pages that go with it. Where there's not a number, it just is something that correlates with the above number. The first picture, or the first thing is I just did an aerial photo of the property that we're talking about this evening. It is 16.86 acres. I have 610 feet of shoreline. Currently, I do have a B1 general business zoning. It's in zoning or zoned. Currently, under the B1, it has 76 permitted uses and 29 conditional uses. The assessment that I have placed on it actually is $3,522,800. What the makeup of that number is, I have 610 feet of shoreline using a depth of 400 feet back, which encompasses 5.6 acres. And I have $5,500 a running foot on the 610. That gives it $3,355,000 value. And then what I did is I looked at the assessments over this last year. Previously, the assessor had so much a square foot for the remaining 10.26 acres. There was 1 acre that was deemed at a previous border review that was wetlands and that was not valued. So he had on the rest of the 10.26 acres, there was a per acre value, a square foot value. I did away with that and used the standard depth chart, which is exhibit number, it's on the packet, but it's page number 2. As you can see, it doesn't, if you look on the far bottom right corner, it goes to 390 feet. I use 400. I just added 5% to the original value to come up with the $3,522,800. The methodology behind that is typically we use depth. I also know that there would be this property, the majority of the value is on the water and not the depth behind it. I just felt it was a little fairer methodology than using square footage versus, and that's fairly standard. I looked at standard lots along there and they were roughly 250 feet along the rest of Little Sister there. So I just felt it was much better to use that method versus the previous method. One of the things is, and I know there's a question as far as the classification of the property. We, as assessors, have to first value the property and then classify it. The property assessment manual talks about highest and best use. That's number 3 in the packet. It's about the middle of the page, and it'll have bold letters, highest and best use. Do you want me to read what the definition is, or I don't know if you need to.
Would anybody like the definition read?
No.
Okay. That is the basis of we look at what's the highest and best use. What is the property? Would it be used for And then once we set the value, then we set the classification. If you look at behind number 3, it's the third page back there, on the bottom would be 7-9. These are out of the Wisconsin Property Assessment Manual, and it talks about full value, use value, and market value. The state of Wisconsin changed the assessment process in, I think it's 1998, and added use value to, we used to be a full value or market value system. When they changed the law, actually it was on the book since the 70s, but there was nothing behind it as far as verbiage for the law. They changed that in 1998 to go to use value. So we have 2 different type of systems, and residential, commercial, manufacturing, forest, and other, which is the farm buildings, are market value. Agricultural is use value. Agricultural woods is 50% of the actual wooded value, and then we have undeveloped, which is just 50% of the market value. So we actually have those 3 type of, or the 2 actually, use value and full or market value. You know, the description in the italics, in the center of the page under market value gives a good reason that, you know, we're looking at arm's length sales, we're looking at what is it going to be a willing buyer, willing seller. Then I also have another definition about land valuation, you know, where we have to look at location, we have to look at its local, because you can have a piece of land in the middle of nowhere and it's going to have a different value than in downtown Sister Bay. So it does talk about highest and best use, location. Then on the number 4, the last page, I put the definition of undeveloped land. Undeveloped up until 2003 was called swamp and waste. And with that, basically it says here, swampland or wasteland is defined under statute, including bog, marsh, lowland, brush, uncultivated land, zoned as shoreland under statute 59-692, as shown on the wetlands final map under section 2332. I do have the definitions of both of those statutes on the back behind this, describing basically its zoning of wetlands under navigable waters, and then the wetlands mapping. So, and then if you look and continue through there, it says, or other non-productive land not elsewhere classified. So basically, undeveloped is a catch-all. It's when we can't, as assessors, put a value or not a classification on a particular piece of land because it's useless. It's an empty borrow pit. It's a gravel pit that's not being used anymore. It's just a rock bluff that, you know, the lot is all rock. It's all marshland. It's just something that, it's a catch-all, and that's where the undeveloped comes in. And I don't see that the West Capitol property at all is in that situation. I did look at, and there is no, according to the GIS, there isn't any wetlands that is out there. Now, I know that there's some hills and swales or swales on the property from reading notes. I've not actually walked the property, but there is, you know, but I don't see that there's any actual wetlands to the property. So I don't see where, you know, it can be undeveloped because it is a piece of property that is on the shore. It's very large, it's accessible. It's got roads on 2 sides. It's got, you know, it's zoned. It's got access to sewer, which is, I think, running down one of the roads at this point. So I don't see where it can be undeveloped. I also did list some of the sales that I did look at when I created the value. I looked at sales from basically Village of Egg Harbor North Trying to find, first of all, commercial water sales. While there isn't any of them, I haven't found any of them in the last couple of years. I looked for large vacant water sales. I did not find any of those, so then I went to the next thing, which was larger residential sales, and then used the extraction method to remove the buildings to come up with a land value. The first one is the latest one that sold. It is in the village of Ephraim. It sold on 8/13 for $997,000. It is a little bit smaller on width. It's 105 feet of frontage. It's 0.94 of an acre. It's an older log-style home from the 60s. It is well-maintained. It's approximately 1,550 square feet. I came up with a value of $192,800 on the building, which then equates that the shore frontage, that shore frontage value is $7,660. With some adjustments, because obviously our subject doesn't have sewer at this point. It has access to it, but this one in the village has sewer. It's got similar views to the property. Obviously adjusting for the size of it, it would put it real close to the $5,500 per foot that I am currently assessing at. Then the next one is in, this one is in the village of Egg Harbor. This one sold in 8/11 for $3.5 million. It consisted of 226 feet of shoreline. It did have a home on it. 30 days after the purchase of, or the closing of this property, the house was removed. There is a very large permanent pier on there. I gave a contributory value of $750,000 on the pier because it's almost 400 feet. I think it's like 280 feet long. So removing that from the sale price, not making an adjustment for the home because it was removed, or not adding any value for tearing it down, you have 226 feet divided by 2,750,000. You're looking at $12,168 per front foot. Then there was two other parcels that the same owner purchased right next to his, this one we just mentioned. He bought it in 12/11 for $975. It was 115 feet of shore, 0.77 of an acre. There was a house on it, but again, all the houses were removed. He leveled them all. At 115 feet, it comes out to $8,478 per foot. The third property, it sold 12/11. I think they closed them both at the same time. We're looking at $975,000 for, again, 115 feet. You're looking at $8,478 per foot. If I actually put them together, they are separate parcels today. There is two homes on it, 3 parcels. I'm looking at 4.95 acres and a value of $470,000, which is minus the pier value, and it's 456 feet for $10,300 per foot. And again, now if I made some adjustments for having municipal sewer to each one of these lots, now you put the 3 together, you're looking at $10,000 a foot. Maybe my $5,500 is a little bit low. But making the adjustments, it would still put it, my value would still be justified. The last one is in the town of Gibraltar, sold in October of 12 for $1.3 million. Has 2.56 acres with 150 feet of shore. I extracted the home, it's 2,350 square feet. I placed a value of $300,000 on that. When you divide what is left by 150 feet, I come up with $6,660 per front foot. You know, I did look at I mainly looked at the market approach because of the fact that That was the most reliable cost approach while there is no buildings on the property. And I did not use the income because obviously it's not an income-producing property. My value is $3,522,800. That's all I have at this point.
Mr. Jared?
Thank you very much.
Mr. Potter, I'm sorry.
Okay, Mr. Zacharias, how long have you been an assessor?
I've been certified since 1985 as a technician, somewhere in the late 80s, early 90s as a level 2 assessor.
Okay, is it fair for me to say that you are generally familiar with the statutes that dictate how assessment are done?
Yes.
And is it fair for me also to say that in rank of priority, the statutes rank higher in priority or are to be given overwhelming weight in compared to the Wisconsin Property Assessment Manual?
Well, I mean, I have to follow statutes, yes. And also, well, and the manual also, which I think are kind of hand in hand, but
Do you understand that today, if the evidence before the board shows that the assessment hasn't followed the statutes, that the assessment must be set aside? Is that the standard we're looking at?
yeah, correct.
Now, is it also correct for me to say that the statutes require you to assess properties as of the end of the day on January 1 of each year?
Yes,
And as part of the assessment process, you have to make a classification of each property into one of 8 different classes.
yes,
And though the statutes require that you classify each parcel based upon its use.
no, I disagree with that.
You disagree with the statutes require you to classify parcels based on its use?
Because when with what I'm required to do is create a value, then classify, and it's not all necessarily on use.
Do you have to classify every single parcel, is that correct?
Yes.
And how do you determine how to classify it?
Well, I look at each parcel, what it is, where it's located, the proximity, size, location, type of soils that are there, is what typically I end up looking at.
Are you familiar with statute 7032, real estate and how valued?
Yes.
Do you understand that under 7032-2A, it indicates that the assessor shall segregate the following classes on the basis of use?
Yeah, it is in there, yes.
Okay. And so you have to segregate the property based upon its use.
Well, I think it's a little out of context if you read above it, part of 7032. It talks about valuing assessor specified by manual provided under 73032A from actual view, best information that the assessor can obtain at full value, which could ordinarily be obtained there under a private sale. So, going to 2A is, to me, that was added after when they created the ag use value. So if you're just looking on that, I think I think the board would have to look at the whole section 7032 statute.
Oh, sure. And so you have to create your value, and then you have to classify it.
Correct.
Right. And that's kind of how the statute is laid out. You do one, and then you do the other.
Yes.
And when you go to classify it, you classify it based on use.
I typically, if it's not ag land, I look at the highest and best use first to classify it versus the actual use.
Does the statute require you to classify based on highest and best use?
The Wisconsin Property Assessment Manual does. I cannot say for sure if the statutes say that.
So you do not know whether 7032 indicates highest and best use?
Correct.
But you do believe that that term, highest and best use, comes from the property assessment?
That I do know, yes.
And you've provided a part of that in your exhibit? Is that
Yes.
correct?
Yes.
Now, on January 1st of this year, you classified West Capitol the West Capitol property as commercial.
Yes.
And on January 1st, was the property actually being used for any type of commercial use?
No, it's not.
Did you go to the property?
I've been to it because of my maintenance. I've been through there several times during this last year.
And you were able to view it?
Yes, I did not walk on the property, but I mean, I went up and down each side of the road of it, yes.
Were there any buildings of any sort on that property?
No,
Are there any goods manufactured or fabricated?
no,
Has the property been used for buying or selling any goods that you could tell?
not that I'm aware of.
Did it appear that the property was being used for any sort of farming or agricultural purposes?
No,
Did it appear as if the property was being used to harvest any sort of timber or materials?
that I didn't look to see if they did that, so I'm not sure.
Did it look as if the property was being used for any type of commercial purpose?
It's a piece of a vacant parcel. Yeah, so I guess I would say no.
So if it's not being used for any type of commercial purpose, why classify it as commercial on January 1?
Well, because, number one, because of the location, it's next to Fred and Fuzzy's, there's the Little Sister Resort, and it also is zoned general business. So I looked at the proximity and the location compared to the other parcels that are there, and because of the zoning, I applied the commercial classification.
Okay, so based upon the zoning and based upon the other parcels in the nearby area, you determined that that property should be commercial.
Mm-hmm. Yes.
Did you look at any other factors as to why that property should or should not be commercial?
No, I did not.
Did you contact West Capitol in any manner to find out what their intended use of the property is?
I did not.
Do you have any reason to believe, besides the surrounding parcels, that the best use for that property is commercial?
Not other than the permitted uses by the village, you know, the B1 zoning, it has a lot of possibilities to be used. Like I said earlier, 76 permitted uses, 26 conditional uses that would be allowed.
Is it fair for me to say that when choosing a highest and best use, it does take a level of guesswork in coming up with what the highest and best use for a parcel is, whether that be commercial, residential, or any other type?
Well, I don't know if it's guesswork, but it takes, you know, would be my opinion based on the years of experience that I have.
And you don't believe that it is in any way speculative?
I do not. And I guess, you know, whether it would be residential classified or commercial, the value would be the same. I'm not treating either one differently, so. And you can have, I mean, it can be multiple uses. I just looked at because of the commercial properties next to it that I felt it was commercial.
So really, the major factor was the surrounding parcels?
Mm-hmm. Yes.
Did you also indicate previously that it had 1 acre of wetlands?
In the assessment card, the Board of Review, and I don't know which, it looks like the Board of Review in 2009 deemed 1 acre worthless, and there was a reduction of 87.5. there is a, I thought there was a picture in here that this is part, somebody drew on the aerial photo roughly a circle there. This is part of the record that was here. I'm just looking at the notes from the previous board review. So, and maybe I misspoke on saying wetlands, but it's deemed useless for some reason.
And have you been to the property to see that space?
I have not walked out, no.
Have you walked on the property to see whether or not there are rock outcroppings or anything else on the property that might make it unable to be productive?
Like I said, I went down the road, I got out, looked at the shoreline, but I did not actually venture into the property.
So without being on the property and not being able to determine if there are parts of the property that make it unable to be productive, how can you determine that it is a highest and best use of commercial?
Because the parts that I did view, and the majority of the value is on the first 400 feet off of the shoreline. And that appeared, from what I could see from the road view, it appeared to be fine.
So from the road, you're viewing almost 17 acres of land.
Well, like I said, I looked mainly at the first 400 feet of that.
I want to have you turn to the page 4 of the exhibit that you submitted, passed around. Should have number 4 circled in the corner at the bottom, 5-17. About the middle of the page, it indicates undeveloped land, class 5. And this is the provision that I think you indicated in 2003, the state legislature changed from that swampland and wasteland to now this undeveloped land category.
Correct.
And would you agree with me that that change really kind of widened the definition from swampland and wasteland to another myriad of objects like bogs, marshlands, brush, and other non-productive land not elsewhere classified?
Well, I don't think it really added anything, because under the swamp and waste, it was always still the catch-all. Anything that we couldn't come up with a reasonable classification got put in here. So, and I think they just didn't particularly care for the swamp and waste category versus the undeveloped. So I don't really think anything has changed over the last 20, 30 years, because swamp and waste was always for something that wasn't, it was just a catch-all that we always stuck stuff into it that didn't easily meet the other criterias.
So when you can't classify something, you classify it as undeveloped?
Typically, yes.
And under this, it indicates, after the definition statement, the second sentence starts, this land, this class also includes land which, because of the soil or site conditions, does not produce and is not capable of producing, such as rock outcroppings, borrow pits, abandoned and depleted quarries, or other land not used and with no potential for use. How can you be sure that that does not fit the classification if you did not view this property in full besides just from the road?
Well, because like I said, when I went through the GIS and did a wetlands and a DNR floodplain, and did not see anything that indicated that there was low areas that would deem it to be wetlands or flood areas.
And even in light of finding previous board notes that said that there's at least 1 acre of this almost 19 acres that is worthless because it's wetland.
Well, like I said, I'm not sure if they're deeming it wetlands or if it's just unusable. Like I said, the note on the back or on the front of the card was 1 acre is worthless. So I would be interpreting something.
And is it, let's see if you have this other section of the property assessment manual. Hold it for just a moment. Is it your understanding that the property assessment manual requires that the highest and best use not be speculative?
Yes.
So besides, here it is, sorry. Page 3 of the exhibit that you provided under highest and best use, looks like it's 1, 2, 3, fourth paragraph down, it indicates the highest and best use should not be highly speculative use. And that the use should produce the greatest return over a reasonable time period. I guess one of the last couple questions I have here is, what is it about this property that makes you believe that it has a highest and best use of commercial versus, I guess, non-developed? When for nearly half of a century now, nothing has been done with this property. We're pushing, let's see, over 43 years now. So a great return over a reasonable time period is really what I'm getting to with 43 years. And the property, you really haven't been able to go through to see if it is able to be productive. What is it about this property, not the surrounding properties, but this property, that makes you believe that its highest and best use is commercial?
Well, like I said, I'd looked at it, it's a large parcel with shore frontage, and the zoning is right for many other uses other than what it is. Now, as far as being vacant for 40-some years, in its natural state, I guess that's the choice of the owner to do that. You know, nobody's, I can't answer why they left it that way, but it's their choice to leave it that way versus whether they developed it into residential, whether they developed it into commercial. But to me, does not fit the undeveloped classification because of the fact that it is looking with having the shore frontage on and that size, it would be a very desirable piece of property because of having 600 and plus feet and roadside on two sides of it. It is not just something that you would hunt on, which with marshland, bogs, it isn't something that's been mined or depleted from the aggregates that would be under there. So it just does not fit into the undeveloped classification.
I think with your previous testimony, you indicated that you did not use an income approach in getting to your valuation, is that correct?
Correct.
And can you explain again why you didn't use the income approach?
Well, because there's nothing on there to produce an income. Because it's a vacant parcel of land.
And so even though it doesn't produce any income, you still don't consider the property non-productive?
Correct.
And is that because you believe it is able to be productive?
Well, because under the current zoning and what is there and what is available with the sewer, if there's something can be done with it. But I'm not speculating that you can put 42 condos, 62, 100 condos, a manufacturing plant. It's just that it's a large piece of property that has the highest and best use is more than undeveloped property.
So you are speculating that it has some sort of commercial use?
Well, I'm looking at the highest and best use. There is some, but I'm not highly speculating. It's zoned properly. If West Capitol chooses to do one of the 76 that is actually permitted, they don't have to change the zoning. They can just go into the village, submit plans, and do as they choose to do. So that's, I mean, I don't know that I'm speculating. I'm looking at what is the highest and best use of a vacant piece of property.
further from Mr. Zacharias.
Does anybody on board have any questions?
I have a few things I'd like clarified through the objector's form that was filled out, if I may. On the first page, it says amendment to objection form. It's under the number 1. It's underneath item 4, but it's the 1. You stated the assessor's reasoning is wrong for 2 respects. The first, the Supreme Court case was held valuing the property on the basis of an action that may be taken in the future, wholesale speculation, and it says C. MacArthur versus State 239. I looked up that. I did not make a copy for everybody. This reading on it, if you look, now do you have Jared, do you have a copy of it?
I do, yeah.
If you look on page 4, under the number 3, it would be the left column down on towards the bottom.
Yep.
It's about the 3rd or 4th sentence. This was the opinion of Chief Justice Rosenberry. It states in here, we must start out the case with the proposition that we are not dealing with the valuation fixed by the assessor for purposes of taxation, which has been approved by the Board of Review. When I read this was basically about probate. I guess I don't know why it's being used, because it isn't affecting, they weren't contesting the assessment. The state was taken to court via the fact that they had an appraisal done for a lot more money than what they ended up selling it for, and it was based on probate taxes. So I'm not sure why it's relevant to this, especially when it states in there that they're not actually looking at, because you had in here said it's, it's not, and then on the next page, you're talking about section 7032(1)G. It says, provide real estate property shall be valued by the assessor in the manner specified under the Wisconsin Property Assessment Manual. The manual expressly requires the assessment to be based on property's actual use as of the first of the year. And then there's some highlighted where it says the annual determination of use for the property tax classification is controlled by the use and found as of January 1. Well, I looked up 7032(1)G, and it says agricultural land means land exclusive of buildings and improvements and the land necessary for their location and convenience that is devoted primarily for agricultural use. As I had said earlier, I think the use in there is for this new agricultural use value, because your 7032(1)G doesn't, I don't know where it came from. I'm not sure what that covers. Then just under that, you had stated about the property assessment manual on page 549. The assessor failed to classify the property based on January 1 by failing to base the classification. I'm not sure if you guys were using an old manual, but I did copy, and it has nothing to do with that. I'm not sure.
Yeah, I believe it came from an old manual.
Okay, because I don't have the old manual, so I didn't look it up. I was a little bit like, I didn't understand that. Then the next one down, it's talking about evidence before the board shows the assessment has not been fixed upon statutory basis. The assessment should be set aside. This is the State versus Gartman Toy Company versus Mosel from 1966. This is actually in the manual. It's on, here, pass it out so I don't have to. It's the second full case down. And if you read it, it's talking about personal property
Which one
and
is
the
it?
value of the personal property.
The second one down, Garden.
Yeah, Gartman Toy versus Town of Mosel. Again, it says evidence that shows the assessment should be fixed, and we should set it aside based on this case law. Well, again, I don't think the case law is relevant because it's personal property, and we're not dealing actually with that. Then under the number 2, just under that, we were talking about vacant land, and because it should be devoted primarily for business reselling of goods. You know, it does say that we can have land we can have vacant land that is assessed as commercial. Doesn't have to produce income. And, you know, there's parcels all over, and I guess there's an example in Green Bay, everybody knows about it, Walmart's being put on it. It's a vacant piece of land. They're looking at several $1 million for that vacant piece of land. I'm sure it's not classified as undeveloped. It's been vacant for quite a few years since they tore the canning company down. So, I mean, I just don't understand, because it is something that one is zoned for particular uses, and so is this one, and has the option of doing many things. I don't have anything more at this point.
Attorney Potter?
Just a few items to rebut. I think there was 4 or so points that Mr. Zacharias was making. The first, I guess we'll look at MacArthur versus State, which is also in Ray Ryerson's estate. That's RYERSON apostrophe S estate. This was a probate case in which the assessment was not challenged at the board level. However, it does still stand for the proposition that value for a property must not be made on purely speculation. That is in part of the court's concluding, which is on the last page of the document, indicating a value based on what may be made a subdivision of the property is purely speculative value. In that case, they were looking at whether or not this property should be subdivided. It wasn't subdivided, it was speculation. And that's the kind of the point of the case. Yes, they were not challenging the assessment, but it still stands for the same principle that the value of the property cannot be speculative. And that is reflected also in the assessment manual. The assessment manual indicates that the use cannot be highly speculative. I apologize for the old sites. I believe when this was being worked on, it was being used, they used an old manual, unfortunately, which is why I went through and tried to update that with the statutes of going through Mr. Zacharias' testimony. I didn't recite the statutes, but that was the purpose of going through the beginning part of saying, isn't it correct that you have to value it as of the first of the
Sure.
year? And isn't it true that it has to be assessed as of its current use? That was the purpose of going through those beginning points, because I did notice that some of these statements in the objection were outdated. I am unsure of the total circumstances for the Walmart parcel that I think Mr. Zacharias mentioned, and the parcel being undeveloped currently. It sounded like he indicated that it was previously developed, even though this parcel has never been developed ever. It's never been touched. It is literally sitting vacant for nearly, like I said, half a century. And the last part is the item that was passed around by Mr. Zacharias. This is a very brief part of this case of the Garden Toy Company. Obviously, that is not the full opinion that is listed here. Yes, it is a personal property assessment. However, the statement in the objector's objection, I think, still stands. Even though it is a personal property assessment, it still stands for the same rule of law. So I have nothing further for Mr. Zacharias.
Now close the testimony and motion. Well, you can declare the testimony closed and then look for a motion as to how to proceed with the approving the assessor's value or the.
I'll have you explain that. Okay. Is there any further testimony from the objector?
No further testimony.
Any further testimony from
No.
Mr. Zacharias? Okay. I will close the testimony in this case. I would ask our village attorney to explain to the Board of Review what our objective is in any motion or vote that we're going to take.
Any motion on what?
Any vote or motion that we're going to take. Okay, the role now is on the Board of Review members to decide how you want to deal with this testimony that's been presented. As you're aware, and as you've probably seen in the materials that we've looked at before today, the role or the burden is on the objector to convince you that the assessment made by the assessor is incorrect. The assessor's value of the property is presumed to be correct unless the objector has established that it is incorrect in some way. I'll tell you that as a Board of Review, your role is not to question the classification of the property. The classification is something that's set by the assessor. If the court upon appeal feels that it's incorrect, he will tell this board in the court's decision why the court feels that the classification is wrong, but it's not up to this board to change the classification. The assessors made that determination. This board's objective is to determine the valuation of the property. And the assessor has given us his value, his opinion on the value of the property. The objector has also provided an opinion as to the value of the property based upon the information that they presented. Now it's up to this board to proceed to deliberate. Best thing to do at this point is for someone to make a motion either approving the assessor's value or or to change the value based upon information provided by the objector, and then proceed with a deliberation based on that motion.
I'll make a motion that we agree with or uphold, whatever the proper verbiage is, the assessor's value of the property.
Is there a second?
I'll second.
Oh, you seconded it?
I'll second it.
Okay, any discussion? I would just point out one item on the addendum to objection form that wasn't spoken about testimony, but it's in evidence, and that was in item 5. To Randy's point that we're not here to review the property's classification. In taxpayers' opinion, the full taxable value of the property as of January 2014 was $2,420,000. However, the taxpayer is not challenging the assessor's $3,522,800 amount, only the property's classification and its effect upon the assessment. Questions, discussion?
And nothing.
And a vote would be in order. We have a motion and a second. All in favor?
Aye.
Opposed? Carried.
The clerk will provide you with the revised, or the assessment determination. Christie, you going to be able to do that?
That's it, thank you.
No? Got it? Okay.
Thank you so much.
Thank you.
Thank you.
No.
Thank you. Talk too fast? Oh, okay.
Do we have anybody else? Gentleman in the back.
No.
I'm gonna give her a call, yes.
You can turn the recorder off. We have to stay officially in session until 7:05.
7:05.
Yeah, because a lot of times,
Yeah.
so I don't always.
Okay.
A motion to adjourn the board of review would be in order for 2014.
I'd like to make that motion to adjourn the board of review for 2014.
Is there a second?
I'll second it.
All in favor?
Aye.
2014 board review is now closed at 7:06 PM.